The Constitution gives an absolute grant of authority to this chamber, not to the folks across the hall, not to the governor downstairs, not to those folks across the street. It gives it to this chamber. So I urge you to table the motion to recall.
Senator Macon.
Yes, sir.
Senator, yield for a question.
Yes, sir.
Senator, you brought this up, and it doesn't have to do with the motion, but tell me again why it takes 5 votes instead of 3 votes, because to put a roll call, because I thought our rules was 3, but they keep saying 5.
The rule 16 is, by rule, we can adopt, in my judgment, in the Senate's judgment, a lesser threshold. We have the authority under the Constitution to, in my view, to do that. And we've done that. We adopted a very comprehensive Rule 16. But I do hope the fact that we set up a committee meeting, we don't intend to just sit on the bill and not let folks air their grievance. And if I hadn't had a committee meeting scheduled, I'd say, well, yeah, I mean, if I didn't know we were going to get to it, it's a House bill. But we've got a committee meeting scheduled, and we'll let the process run its course. I don't understand.
I don't understand why you don't understand. I don't know.
I don't understand. I don't understand about this. That you don't understand that this is the law of this Senate right now.
If it is, then what's wrong with passing the statute? What's wrong?
Statute.
How does that affect us constitutionally?
Constitutionally, it has no bearing on what we do.
So
just like we changed the rule.
In a resolution to Congress, you say they throw it in the trash.
Well, you know, and the other thing about this, and I know people are going to be listening to our discussion. They're going to be podcasting this out on talk radio, and they're going to say, well, you know, Senator Martin is opposed to putting this in state law, so those guys on a whim can't change it. Senator, you know how difficult it is to change our rule? Don't you?
I'm not talking about the rules. I'm talking about this bill.
You got to go through the legislative process to get the House's permission or concurrence, agreement, and the governor to agree to it. Why do we want to involve the governor in a Senate rule? When did we start doing that?
If the rule trumps all this, why are you concerned?
Well, it doesn't mean anything. There's no meaning whatsoever.
Let me ask you a question.
Yes, sir.
The next time my wife asks for $50 to buy something, I'm going to say, I can't do it. And she'll say, well, I'm going to say, it's unconstitutional.
Wouldn't you agree that really Article 3, Section 12, which gives to each body,
each house,
the authority, to each chamber, the authority to establish its own rules, isn't that an application of the separation of powers doctrine?
Absolutely.
My question is, should the motion pass, are you then going to ask us, say, well, you know, we did put it on the calendar, let's bring it through the subcommittee with it maintaining? Is that what you would suggest?
Well, if the Senate, it would take a unanimous consent request to do that.
That does take unanimous consent.
That would take unanimous consent at that point, and I think the chairman of the committee would object to that.
My question was, you have scheduled a subcommittee hearing.
I have.
And this bill only came March 30th.
That's correct.
So it's been here about two and a half weeks.
Right. 3 weeks, because we were out the first full week
I would hope the Senator from Buford would at least talk about the committee system and the subcommittee system before he insists.
Right. I would move table the amendment. I mean motion.
I've tried cases and argued cases across the street before the Supreme Court. I know this Constitution inside out. I am aware of the provisions they're citing in Article 3, Section 12, that each House shall determine its own rules of procedure. If this body decides it wants to dictate those rules by statute, there's nothing inconsistent with the Constitution here. There's absolutely nothing inconsistent. And what I find ironic is that somehow the state constitution is being used as a shield against more on-the-record votes. And I just don't believe, you can't convince me that the state constitution is going to be interpreted by that Supreme Court in such a way as to limit the people's right to know how their representatives are voting on an issue. I don't believe it. I don't make these motions lightly. It's the first time I've ever made a motion like this. I don't think this matter is going to be able to make its way through the committee system, given the calendar we have. I think this is the only practical way we're going to get to it this session. Otherwise, I'd go through the committee process. Senator Peeler has had his bill filed for months and hasn't gotten a hearing. And I honestly believe this is the best way for us to consider this. I promised my constituents we'd do that. And I don't think the state constitution is ever going to be interpreted in such a way by that Supreme Court as to limit the people's right to know how we vote on issues. I don't believe it.
Well, Senator Yield.
Senator Yields.
Senator, would you accede to one correction of your comments? Number one, the committee did have a hearing on Senator from Cherokee's bill.
Okay, I was mistaken. It wasn't passed out. I apologize.
It was not passed out because of the information that we, and as I said earlier, would you not welcome the opportunity to come to the meeting? I don't think you were at that hearing when we had it, and we can discuss. I think there's a legitimate difference of opinion on our parts about and I didn't say it was unconstitutional. And I didn't say it was unconstitutional. And I didn't say it was unconstitutional. The court, I would never make the argument of the representation of the Senate or to anybody else that this would be struck down as unconstitutional. The court, I would never make the argument of the representation of the Senate or to anybody else that this would be struck down as unconstitutional. I was talking about the judicial review that would be given to it. The judicial review that would be given to it, would you not agree, based on your reading of past cases, all those bobtailing rulings, they go back and they talk about what's in the state constitution.
They do,
and
but
they specifically say in their I can and we'll get those. They specifically say in their cite, they don't look to the statute, they look to the Constitution.
But the Constitution enumerates certain things that must be subject to a vote, but that in no way precludes this body from expanding that recorded requirement. There's nothing precluding us from doing
done by rule, but also which I am not willing to delegate to the other House or to the executive, as you apparently are willing to do by passing a statute.
And that's a debate on the merits, and we can have a debate on the merits, and there may be there may be arguments against and for this bill. I'm just simply wanting it on the calendar.
The next question is what else is going to be the fad of the moment?
Senator from Pickens, I respectfully disagree that recorded votes are a fad of the moment. I think this is critical to representative democracy.
Let me tell you something. The Rule 16, you know, the last thing, have you seen the email